he didn't show up last week, and you gave us a week to
Right.
get him in. So he's present. If we can just reset it, I believe what we're doing is it's a pre-trial PTD judge, and
Okay.
I'll double check to make sure that that application got in.
All right, make it so, Patricia.
Thank you, Judge.
You're welcome. All right, at this time, the court calls cases number 654434, State versus Vanessa Gomez, and 667343, State versus Mason Williams. Mr. Williams is accompanied by his attorney, Joseph Stateson. Ms. Gomez is accompanied by her attorney, Liz Russell. Ms. Gomez, where are you?
Right here, sir.
There you are. Okay, you're in the courtroom.
Yes.
And Mr. Williams, where are you at?
I'm here, Your Honor.
There you are. All right. Mr. Williams, Ms. Gomez, would you please raise your right hands? Do each of you solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth? Ms. Gomez,
Yes.
Mr. Williams,
I do.
thank you. You may put your hands down. Gentlemen and lady, before we proceed, I need to discuss with you on the record. I have a court reporter, Ms. Kayleen Rivera, who's making an official record of this proceeding. This is a verbal discussion wherein I inform you of your constitutional rights and protections. First of all, the right to remain silent. Each of you cannot be compelled individually in respective case, cannot be compelled to make a statement. You cannot be required to answer questions nor to submit written paperwork that has your signature, particularly any papers that admit or confess to wrongdoing. That's called the right to remain silent. You understand you have that right, Mr. Williams?
Yes.
Mrs. Gomez?
Yes.
Each of you has the right to a jury trial. That means that in your respective case, each of you and your attorney in the state could select 6 people from a pool of disinterested citizens to hear all the evidence, testimony, observe whatever is presented in a trial at which the 6 jurors would decide whether you are not guilty or whether you have actually been proven guilty beyond reasonable doubt. It's called the right to a jury trial. You understand you have that right, Ms. Gomez?
Yes.
Mr. Williams?
Yes.
Each of you has the right to confront witnesses. What that means is if you decided to go to trial, the state would have to present witnesses to try and prove up their case. Those witnesses, you would have the right and responsibility to question, challenge, cross-examine, of course, for your purposes as a defense. That's called the right to confront witnesses. You understand you have that right, Ms. Gomez?
Yes.
Mr. Williams?
Yes.
You each have the right of appeal. That is a bit of a difficult right, but it is important. That means each of you, individually and respectively, and your attorney or yourself or the attorney by yourself or the two together, each of you individually in your case has the right to demand that a higher court review the official record, all the evidence, testimony, etc., for whatever legal challenge you wanted to make. That's called the right of appeal. I would remind you that it is a difficult right in that you have to use the correct materials and the substantive materials and information in the documentation that you use, and it includes time limitations. You understand each of you has the right to appeal. Mr. Gomez, Ms. Gomez, pardon me.
Yes.
Mr. Williams.
Yes.
Furthermore, each of you individually, respectively, has the right to demand that this proceeding and all proceedings be held in the open public courtroom, County Court 5 in this case. because of the COVID pandemic, we are not doing that. But in order to proceed, each of you apparently has reviewed and signed a document called Defendant's Consent to Video Conference. That document and others, it is my belief or observation that you have reviewed every document that has your signature in this proceeding, and you have signed it with the assistance and counsel and advice of your own attorney. Is that accurate, Mr. Williams,
Yes.
Ms. Gomez?
Yes.
And specifically, you have each signed the consent to video conference. Ms. Gomez,
Yes.
Mr. Williams.
Yes.
Now, in executing your jobs, attorneys, Ms. Russell and Mr. Statson, you have each signed an affirmation that says that you agree and acknowledge that the state has complied with Article 39.14 Texas Code of Criminal Procedure, in that they have complied with the requirements of discovery. Is that accurate, Ms. Russell?
I have and they have, Judge.
Mr. Statson?
I'm satisfied they have complied. I'm
My
not
question
certain
is,
if I've received the discovery acknowledgement or not, but once I receive it, I would sign it, forward it to the court.
Okay. All right. Now, Ms. Gomez and Mr. Williams, each of you signed a document that's very important. They're all important, but this is critically important. It identifies you individually, name, case number, court number, and it is titled, stated, the defendant's waiver of constitutional rights and court's admonitions. Are you familiar with the document I'm referring to, Ms. Gomez?
Yes.
Mr. Williams?
Yes.
Did you see and understand that it talks about what you're pleading to, how you're pleading? It has 14 numbered sections in there that include a review, an acknowledgement on your part that you are aware of the rights and protections that you are afforded and that you are surrendering. Did you see and understand that information, Mr. Williams?
Yes.
Ms. Gomez?
Yes.
Did each of you see and understand that you're told in there clearly that whatever agreement you have made with the state, it is not binding on me as a judge? Did you understand that, Ms. Gomez?
Yes.
Mr. Williams?
Yes.
It informed you in there particular that it is my authority and responsibility to say yes or no to your plea bargain. In addition, I can give you any punishment within the range of punishment allowed for your particular offense to which you plead, and even if it's greater than what you agreed to. However, if I reject your plea bargain, or if I give you a punishment within the proper range, but greater than what you've agreed to, in either of those two events, the law would allow you to start all over again, and nothing that you've said or signed would be used against you. Did you understand that, Mr. Williams?
Yes.
Ms. Gomez?
Yes.
Furthermore, I've talked to you a little while ago about the right to appeal. There is a document in there that I want to make sure you're aware of. It says it is a certification of the defendant's right of appeal. In each of your respective cases, I have signed and certified a document that says and tells you you are giving up your right of appeal as part of the plea bargain. Did you understand that, Ms. Gomez?
Yes.
Mr. Williams?
Yes.
All right, now, state and defense, is this going to be probation on both people?
Yes,
Mr.
Your
Wi-
Honor.
Is
Yes,
this going to be
probation.
deferred on both people?
Mason
Your Honor.
Williams will have straight probation.
On which one?
Mason Williams.
All right, probation. And on Ms. Gomez, it's going to be deferred?
Yes, Your Honor.
All right. Now, did each of you sign an application for probation / deferred adjudication? Ms. Gomez,
Yes.
Mr. Williams?
Yes.
Probation is a written, legal, binding agreement between you and this court. That agreement specifically includes that you know and understand what you're telling me in order to apply for probation. Did you not understand the documents, Mr. Williams,
Yes.
Ms. Gomez?
Yes.
I include in there and inform you that probation and deferred adjudication are a little bit alike. There's a distinction that's important. Probation, you will be placed under community supervision for a length of time. You will be sentenced to jail in probation, and it'll be suspended for a length of time. There will be fines and other things. And you will be found guilty of whatever charge you plead to. Ms. Gomez, in your case, you will be entering a plea that will be sufficient for me to find you guilty, but I will not. Instead, I will defer, you might say postpone, a finding of guilt. And if you live up to 100% of the conditions of supervision, your case gets dismissed and you're never convicted of that to which you pled. Mr. Williams, in your case, your plea, you will be, in fact, found guilty. You will be sentenced to jail and other elements of supervision. And as long as you live up to 100% of them, you don't go to jail again. The jail part is suspended. Ms. Gomez, if you live up to 100% of the conditions of supervision, your case will be dismissed, and under Texas law, you are not convicted. Now, if either one of you fails or refuses to live up to the conditions of supervision, in your case, Mr. Williams, the state may ask me to bring you in after official notice and would hear evidence. And if the evidence, in my opinion, is sufficient, then I can send you to jail for the amount of time that you agreed to, plus the fine that you agreed to. In your case, Ms. Gomez, because it's a deferred adjudication, if you fail or refuse to live up to 100% of the conditions, then in that case, the state may ask me to bring you in for a hearing after official notice. At that point, if I believe it is appropriate, I can enter a finding of guilt, a conviction that will follow you the rest of your life. If that happens, then you're looking at 100% of the conditions, 100% of the punishment range. So I will review that with you shortly. Any questions so far, Mr. Williams?
No, sir.
Ms. Gomez?
No.
All right. So tell me, state, what will be the plea and the agreement on Mr. Williams?
Your Honor, that's going to be, well, the state will have a motion to waive the enhancement of second DWI, proceed on the DWI first. And my understanding is Mr. Williams will enter a no contest plea.
I'm sorry, say again the last part.
My understanding is Mr. Williams will enter a no contest plea.
All right, plea of no contest. There's a motion to waive the DWI second enhancement. State, tell me why we're doing that.
Why we're doing that, Your Honor?
Yes.
I don't have any notes. I'd have to pull the file.
If I may speak,
I'm listening.
this did not involve a crash with another party. Mr. Williams was found in a parking lot. His vehicle did sustain damage, but there's no restitution owed. No other vehicle was struck. No property building was struck. And we worked out this this deal. He understands it's still enhanceable in the future. If he picks up a third, it will become a felony.
Very good. I'm glad that that has been explained to him. All right. To the officially, well, the motion to waive the enhancement and proceed on DWI first. What says defense?
No objection.
There being no objections, the court grants that motion. To the charge of DWI first. Misdemeanor B, how do you plead, Mr. Williams?
No contest.
A no contest plea in this court is considered a guilty plea. Do you understand that?
Yes, Your Honor.
And it is sufficient for me to convict you. Do you understand that?
Yes, Your Honor.
All right, now. Did anyone threaten you, intimidate you, or promise you anything other than the plea bargain in exchange for the plea of no contest?
No, Your Honor.
All right, state, recite for me on the record, what is the agreement on punishment?
Yes, Your Honor, the agreement is 180 days probated for 18 months.
For 18 months?
Yes, Your Honor.
All right,
$500 fine plus court costs. 60 hours of community service.
6-0.
Yes, Your Honor. DWI intervention course. Victim impact panel live. Top evaluation. And ignition interlock for half the term.
Which would be a minimum of 9 months. Mr. Williams, is that your understanding of your plea bargain?
Yes, Your Honor.
Mr. Stateson, is that your understanding of the plea bargain?
It is, I did want to clarify, I believe the community service hours were slightly higher because the state was going to probate half the fine. And to let the court know, Mr. Williams does have a vehicle. He already has ignition interlock.
All right. Mr. Williams, let's, before I say yes or no, again, that's my authority and responsibility. How do you make a living? What is your income?
Right now I'm working at Bill Miller's as a staff leader, and I'm making around $1,800 a month.
A month?
Yes, sir.
Do you have any children that you support?
No, Your Honor.
Okay.
I believe Mr. Williams has his own apartment and pays rent.
Sure, I understand that. Okay. State, Mr. Stateson is asking whether y'all agreed to probate some of that fine. Hello,
Yes, Your Honor, let me look at my notes real quick. Yes, Your Honor, it looks like we did agree to that.
how much is that supposed to be probated?
Half, Your Honor, so 250.
All right, the court approves the probation of half of the fine so that if you live up to all the conditions, sir, then you'd only pay $250 fine. Is that clear?
Yes, Your Honor.
But you will do 60 hours of community service restitution in exchange, which I think is a good thing. So the supervisory fee will be set at $29 a month. I approve the rest of the conditions as recited by the state. You are sentenced to jail for 180 days, probated, suspended for 18 months. The fine is declared 500, but probate 1/2. 60 hours community service. You will participate in and complete the DWI intervention program. The Victim Impact Panel Live, a top evaluation and recommendations. You'll have ignition interlock installed in your vehicle for 9 consecutive months. During the entire 18 months, you're not to drink any alcohol or use any illegal substances. I've already recited your supervisory fee. Questions, Mr. Williams?
No, Your Honor.
You'll have 7 days to come by the offices of County Court at Law Number 5 to have your thumbprint placed on the documents, in this case, as required by law. Questions state,
No, Your Honor.
Mr. Stateson.
If I could briefly, my client had chosen to get vaccinated to help protect other people and relatives. I was going to see if the court would graciously allow very few hours credit, community service hours for him being vaccinated. And I had one other matter to address.
I will give you 5 hours credit for the vaccination, 5 hours credit. That leaves you 55 to do. Is that clear, Mr. Williams?
Yes, Your Honor.
What else do you have, Mr. Stateson?
Because my client's working, Bill Miller, he does have to drive. I was going to see if the mandatory conviction report to DPS, if that could be held in abeyance for at least 3 months to show my client register, complete the DWI classes. If he can take those classes, I would ask in the first 3 months not to suspend his driver's license.
I don't think he's required to be suspended. Oh, I take it back. You've got this is, for the record, the court does find that Mr. Williams is in the classic sense indigent and is not eligible to receive the fine of the 5,000, give or take, because of a DWI second. Be aware, Mr. Williams, that you're playing with fire when you get these cases. Now, you can be hit on final conviction with the 5,000, I believe it's 5,000. I'm not certain of the exact number, but I'm sure that you can find that out and hope you don't find out the hard way. I don't know that I can order a 90-day postponement of anything on this, Mr. Stateson.
All right.
All right. Ms. Gomez, any other questions? Ms. Gomez, to the charge of, wait a minute, State, tell me what the motion is on Ms. Gomez.
Yes, Your Honor. The state moves to waive the 0.15 enhancement and proceed on a DWI first.
No objection.
There being no objection, the court grants the motion. And Ms. Gomez, that means that you no longer are in the DWI extreme intoxication category, which lowers the punishment range for one. Your attorney has also gotten you a remarkable deal in that you're getting deferred adjudication. I've explained to you the details of that. What will be her plea?
No contest.
All right. Ms. Gomez, officially, what is your plea to the charge of DWI first?
Oh, no, say it again.
Oh, no contest. Sorry.
A no contest plea is considered a guilty plea in this court and is sufficient for me to convict you. Do you understand that?
Yes.
I accept your plea of no contest. Did anyone threaten you, intimidate you, or promise you anything other than the plea bargain in exchange for your plea of no contest?
No, sir.
All right. I accept your plea of no contest. I find there is sufficient evidence to find you guilty, including your own plea, but I do not find you guilty at this time. Instead, I am granting you deferred adjudication. The punishment recommendation, State, tell me what it is.
Yes, Your Honor. The term of the deferred is 14 months. $500 fine plus court costs. 48 hours community service. DWI education. Victim Impact Panel Live, TAP evaluation, and ignition interlock for half the term.
Ms. Gomez, is that your understanding of the agreement that's been reached?
Yes, sir.
Ms. Russell, is that the understanding of the agreement that's been reached?
It is, Judge, but when given the opportunity, I would like to address a few of those issues.
I'm sorry?
It is my understanding, but when given the opportunity, I would like to address the court on a few of the terms of that deferred.
All right, let's hear them now.
Yes, Judge. My client, Ms. Gomez, does not own a vehicle, did not own a vehicle at the time of the offense. She was driving a borrowed vehicle. And so we would request that she use the Smart Start mobile device in lieu of the ignition interlock. Additionally, Judge, in terms of the probation fees, we're not asking for any of the fine to be probated, but we'd ask for the probation fees to be set at a minimum. Ms. Gomez works at Methodist Hospital. She makes $16 an hour and works about 40 hours a week, but she does have 3 children that she's raising. She does have assistance from her ex-husband, but with the expenses of the Smart Start mobile and some of the other expenses involved in this case, in order for Ms. Gomez to be successful, we would ask for her probation fees to be set at the minimum. And then finally, Judge, just like Mr. Stateson, I would like my client to receive a 5-hour credit in community service with proof of vaccination, which he has already done.
All right. I accept your plea of no contest. I find that there's sufficient evidence to find you guilty, but I do not. I approve the essence of the agreement in that you are granted 14 months deferred adjudication. Is there an affidavit to the effect of no ownership of a vehicle?
Not yet, Judge, but my client is prepared to sign that whenever necessary. I can prepare that in my office or probation.
Well, all this time that she has apparently been not with the ignition interlock, she has had that. You said that she was on a mobile on this time?
He was never ordered to have a device installed, Judge.
Interesting. All right. As a condition, if she wishes not to have the ignition interlock, which obviously is not practical, I need her to give me an affidavit. First of all, saying she doesn't have a vehicle. Number 2, as part of that affidavit, does not have access to a vehicle. Number 3, will not drive during the period of deferred adjudication. I also want a separate affidavit from whomever or from who was in fact the owner of the vehicle she was driving, attesting to the fact that it was not her vehicle when she was driving and got arrested for DWI. I also want you to attach a copy of the police report, which obviously identified the vehicle itself, not necessarily its ownership, but most police don't know who owns what. Now, the fine, you said you have 3 children, ma'am?
Yes, I do.
And what are their ages?
19, 16, and 15.
Say again?
19, 15, and 16.
Okay, the 19-year-old under law is not considered a dependent, but that's, does the 19-year-old still live at home?
Yes, she does.
Now, did I understand that you're getting child support at least for the 2 younger ones?
Yes, for all 3 of them, sir.
For all 3? That's interesting.
Yes.
All right.
I don't think the 19-year-old has graduated from high school yet,
Oh,
Judge.
especially she goes to college.
Oh, okay.
She attends college.
All right. You'll complete 48 hours of community service restitution. I will credit 5 hours for your vaccine. I think you're saying under oath that you have been vaccinated.
Yes.
All right. You will complete the DWI education program, Victim Impact Panel Live, a type evaluation and recommendations. You will appear in the offices. By the way, you're here now, so you might do it right this moment. You will submit, or rather have your thumbprint applied to the documents, in this case, as required by law. The mobile monitor, you will use a mobile monitor subject to the conditions as I have announced for a period of 7 months. I think it's 14 months, the deferred.
Yes, Judge.
All right, so it'll be for 7 months continuously. Your supervisory fee, because you have, are the children supported by one father?
Yes.
All right. What does he do for a living?
He's a surveyor.
So he makes
for the-
good money?
Yes, he does. For oil
Alright.
and gas.
All right, your supervisory fee, I'll make that $29 a month. The minimum is 25. I think you can do a little bit better. Any questions, Ms. Gomez?
No, sir.
Ms. Russell?
No, Judge, thank you.
Thank you, ma'am. State?
No, Your Honor.
All right.